TTRLA, man, we are back with another clip. You know what I mean? Amen, say, man, make sure you go ahead and like, subscribe, and share to my channel. Like, subscribe, and share to my channel, motherfucker. I'm going to give you 2 seconds. All right, you should be good right here. This is a YNW Melly bond hearing. Not bond hearing, I'm sorry. This is a hearing for his case. You know what I'm saying? So they are in the process of trying to get certain information suppressed. They're trying to get the detective Polo statement suppressed. YNW Melly has 2 new attorneys. His old attorney's gone. The lady attorney, I think, is still a part of it, possibly, but I don't remember seeing her in the courtroom. But I don't know where this case is going. You know what I'm saying? I don't know if YNW Melly is going to get charged as being guilty. I don't know if he's going to get charged of feeling innocent. Do I feel like he had something to do with the killing of his 2 best friends? No. Does it look suspicious? Yes. Based on the testimony of the prosecutions, can that possibly sway the jury to make them feel like YNW Melly is a cold-blooded mass murderer? Hell yeah, because the way that shit is framed is not looking too good for your boy. You know, it's looking like he's an evil doer. You know what I'm saying? He already had a little tape, Melly versus Melly, so, you know, let's tap in though.
Make things short. I've had, in the last 2 years, a hip replacement, and then it got dislocated. I've had a torn Achilles in the other leg, so I don't have a good leg, so I do my best.
Wasn't Brian, I just saw you.
No, actually, I'm walking so much better than I have in the last few years. This is actually a great improvement. But thank you.
Perfect. All right, so let's start. I guess we'll talk about motion suppression number 1.
I would be calling Detective Moretti as our first witness.
Judge, all right, since we're going to be starting with this, the state's going to be objecting to any witnesses being called for the purposes of the motion to suppress. It's clearly laid out in the Florida Supreme Court case law, John v. State and Pardo v. State. I'm going to start with Pardo v. State, the more recent opinion. At 941 Southern 2nd, 1057 from 2006. The validity of an affidavit for a search warrant is determined not from witness testimony, but from the 4 corners of the document. Quoting, ideally, we are skeptical of the claim that non-disclosure of material bearing on the reliability of the search warrant is impeachment material cognizable under Brady. Impeachment is an attack on the credibility of a witness. The validity of an affidavit for a search warrant is determined not from a witness, but from the 4 corners of the affidavit. And that's where the Florida Supreme Court cited itself in Pagan, which is at 830 Southern 2nd, 792 and 806. Determination for probable cause. Determination must be made by examination of the 4 corners of the affidavit, and then they refer to other cases. So I understand that the defense wants to attack the credibility of Detective Moretti, but for the purposes of a motion to suppress and a search warrant, the court is limited to what is contained solely in the affidavit. There are other avenues that they can attack Detective Moretti for purposes of other issues, such as a motion to dismiss and impeachment during trial. But for purposes of today's hearings, with the motion to suppress, we are limited to what is contained in the 4 corners of the affidavit.
Remember, I gave the court the case of Graham, State versus Graham. And if you look at the 2nd page,
Graham. It's in there.
and what training do you have as far as, what training do you have as a police officer?
The initial training at the Police Academy up in St. Petersburg, Florida. That was in 1997. Then through, you want me to just keep it specific to investigation?
Just roughly, just want to hear your experience.
I've been through 3 different homicide schools. The Broward County Death Investigation, then to the Miami-Dade homicide school. Another one taught through Institute of Police Technology Management, IPM they call it. Third homicide school. About 3 or 4 consecutive years I've been to the Palm Beach Homicide Conference. Indeed, that was a 40-hour class and different sessions and stuff like that, specific unique to homicide investigations.
In any of these classes, training, were you taught how to write search warrant affidavit?
Yes, it does come up.
And what was taught, what were you taught?
Specific to the facts to the evidence that you're looking for.
How about have your credentials and you work
I don't remember them specifically because I think we just started doing that not too long ago, putting when the templates for the affidavits were updated. They started having a section for the officer's experience.
Okay, so in the affidavits that we'll be going over in the next several days, or the next 2 days, those come from a template that you and other detectives use in Miramar.
Correct.
Okay. You didn't draft it yourself, is what you're telling me.
Correct.
You just fill in the blanks and then the narrative of the facts.
Correct.
So you wouldn't know whether or not that form was a good form, a legal form, or proper. You just followed it because that's what Miramar was on.
Well, that's what the industry, I would say industry standard, that's pretty much what we're using throughout Broward County.
Well, how many other jurisdictions search warrants have you seen?
I've seen a few other jurisdictions. It all seemed the same to me.
Now, in this case, well, you served the search warrant upon this name, correct?
Not upon this came for the cell phone.
For the cell phone. But that was all part of, you had her come in to meet with you and Ms. Boutros under a investigative subpoena, correct?
I'm going to object at this point to the relevance to the search warrant and motion to suppress the warrant.
So how's the road?
We're getting into his credibility dealing with what occurred there. You had her come in for an investigative subpoena, correct? Suppressible under the Fourth Amendment.
So, again, going back to Pardo, it says the court, I did say the statement, it's the court is bound by that, and that's the restriction in place. As to whether the search by the detective exceeded the scope, that's present or would be present in the actual evidence that was obtained. So if the search warrant didn't allow for images to be searched, or you turned over images, clearly those images theoretically could be suppressible depending if they were plain view, etc. But none of that is laid out in their motions. And the Christmas case and all the cases talk about the defense has the burden of laying out in their motion what particular evidence they seek to suppress. If they're claiming that the detective exceeded the scope of a search warrant, then they need to specify these items exceeded the scope and are subject to suppression. And they didn't do that.
Your Honor, first of all, I'm getting the cart before the horse, but I must be in order to respond. In these warrants, there is a provision in which it states that when the information is received, whether it's from Google, whether it's from cell sites, whatever it is, when it is received, that it is to be segregated for innocuous or innocent material to be set aside. And therefore, if that was not done, then they violated the terms of the warrant. I'm going to submit to you, we're going to find out that in fact they knew when they put that in the affidavit that they were going to do that. And when it appears in the warrant that they were going to do that. They knew from the beginning, or Detective Moretti knew from the beginning, that he was not going to do that. And that is something that I think the court must hear, if I am correct.
So now the defense counsel is speculating. They don't even know. They're saying, well, we suspect we're going to hear. They took his deposition twice now.
We were not allowed to go into it in the second time, you know that.
Wow.
Excuse me, guys. Good comments addressing the.
I'm sorry, but that was totally wrong.
My point is they've taken his deposition. They have access to the records. They've been turned over to discovery.
And
So now they're saying he may testify to it. They don't even know.
Then I'm 100% correct, because we haven't gotten 2 sets of records anything that says this is the ones that have been cleaned by the Miramar Police Department, and these are the raw data. We haven't gotten it, so I don't speculate anymore.
Thank you. All done, anything else?
No.
And you subpoenaed Detective Moretti here?
Yes.
Thank you. I'd like to hear what you have to say. All right, so, understood your motion. Just bring in Detective Moretti.
Yeah, just so for appellate purposes, it's the state's position, this is an abuse of discretion outside what the court is permitted to do for purposes of motion to suppress.
Thank you.
Your Honor, I'm going to ask one thing of the court, and for the court's edification, our own. You have, on several of the past rulings, been trying to find out whether
For the road home this Thanksgiving, shop men's and women's casual looks starting at $20.